for Mr. McMullen, and I went ahead when I was addressing the rest of the remaining defendants and let Mr. McMullen is the last opportunity.
Yeah, I'm sorry. He was trying to say something.
Yeah. No, go ahead. Go ahead.
Yeah, we're good.
Okay. This will be the final opportunity today to enter a negotiated guilty plea, and that would be a plea that both sides have agreed to a recommendation, and if the court accepts the plea but sentences to something outside of that recommendation, Mr. McMullen would have a right to withdraw his guilty plea. After today, any plea that is tendered would be non-negotiated, meaning that if he decided to enter a guilty plea, any sentence that was statutorily authorized would be a possible sentence, and there wouldn't be any right to withdraw the plea simply because of dissatisfaction with the sentence. I just wanted to make sure, and I know, Mr. Dark, you've told that to Mr. McMullen already, but wanted to make sure that's on the record. All right, and I'll ask Mr. Abadi to please let me know what the state's offer was.
Yes, Your Honor. On the 8th of December this year, the state sent an email to counsel for the defendant where the state agreed, or the state's offer was the defendant plead to count 1, conspiracy to commit RICO, and then count 2, but the lesser included offense of murder, voluntary manslaughter, with a sentence of 20 years to serve, all of that time being parolable or parole eligible. It's my understanding that at this time the defendant is not accepting that plea offer, so he'd be facing a mandatory minimum if convicted after trial of life, and a maximum of life without the possibility of parole plus 20 years, Your Honor.
All right, and do you understand that, Mr. McMullen? All right, and as I mentioned before, the fact that there was an acquittal of certain of your co-defendants does not mean that there would be an acquittal in a trial before a different jury with, different prosecutors, different defendants, different defense attorneys. So it's a chance that you are taking, and you obviously have the right to proceed to trial. You also have the right to enter a non-negotiated guilty plea, although you could only enter a non-negotiated guilty plea to the charges that are in the indictment. I, as the judge, don't have any authority to reduce charges. So what I mean by that is, unless the state agreed to permit you to plead to voluntary manslaughter instead of murder, the only pleas I could accept would be to the murder and the conspiracy to violate RICO. So it's the prosecution's sort of venue, if you will, ability, and only theirs, to lessen the charges. Okay, you understand that also? All right. Okay, Mr. Dark, is there anything you want to put on the record right now?
No, Your Honor.
Okay, and we discussed some timing already in your absence when I had the rest of the attorneys here, and what we all have settled on is the state gave an expected duration of trial of about 3 months. They think that's probably on the outside, but that's what we will anticipate at this point. We are going to have a status conference in this case on January 17th at 10 a.m. and we're going to discuss jury questionnaires and the voir dire process and things like that. And can you let me know, Mr. Dark, I know that some of you started the trial that already occurred, started voir dire, and some of you didn't, and I don't know what Mr. McMullen did. Was he a part of the past trial when it started?
Your Honor, Mr. McMullen tells me that he's in custody for the past 2 years with no counsel, so I don't believe that he will participate.
Okay, all right. And when did you become involved in the case, Mr. Dark?
I I just was appointed, I cannot remember right offhand, but I know it was within the last 60 days, I think, Your Honor, 60 days or more.
Your entry was August.
August, yeah.
That's a lot more than 60 days. That's more like 5 months.
It was August in the other case, and then in this case, it was in July 19th. I think it was.
Yeah, 'cause
5
he has
months.
some other case or something.
Yes.
But Your Honor, as I was saying at the last court appearance,
Mhm.
I just got the discovery on this case on, I think, the 11th, and then I don't know whatever his other matter is at.
And as I said to you at the last conference, you should have been able to get all of the discovery from the, oh, you said there was no prior attorney? Okay, well, it was your responsibility when you were appointed to the case in July to reach out to the state and say, hi, I'm in the case now, I need the discovery. So I'm not going to delay the case past the trial that we're going to have of all of the remaining co-defendants. So you're just going to have to spend your holidays getting up to speed.
And to be clear, I'm not asking for a delay. I'm just putting on the record the conditions under which I'm working, and I want to be effective for my client. I don't think that he should just be forced into trial just because, for whatever reason, an attorney was finally found for him after 2 years.
Okay, well, there was no trial for him within the last 2 years. If you were appointed in July, you've already had 5 months, and you'll have at least 2 more months to get ready. 7 months to get ready for a 2-count case is plenty of time. So use your time wisely. Mr. Abadi, did you already provide Mr. Dark with the discovery? I know we discussed that on December 3rd.
Yes, Your Honor. I believe it's everything, but I'm not. I want to make sure I'm 100%.
Okay.
Yes.
All right. So the other dates. Lost my place now. Lost my place. Okay. So we are planning to at least start from the jury questionnaires that were used in this prior version of this trial, which should be filed, and any additions or deletions that you would like have to the court and opposing counsel by close of business on January 16th, and any and all motions in limine are due by close of business on January 15th. The state is going to take a critical look at the discovery and potentially narrow what is going to be used at the trial. So you should have everything now, but everything may become a smaller subset of what you have now. And so they will get that to all of the defense attorneys by February 3rd so that you know what you don't have to worry about in terms of discovery. And we are looking at February 24th to begin the trial. And sometime between January 17th and February 24th, we may, before that date, get the jurors into, we're envisioning them coming in to answer the jury questionnaires on tablets, and so that we've got an electronic version of their answers, and they're here. I mean, they may be here, they may be up in jury in the, I don't know if they'll be in a courtroom or not, but somewhere in the courthouse to answer the questionnaires, then get those to everybody, and then have them back to do actual jury questioning and jury selection. So we'll talk about the ins and outs of all of that on our January 17th conference. All right. So do you have any questions for me, either of y'all, with regard to how the case is going to progress? All right. Okay. Then how about you, Mr. McMullen, do you have any questions for the court? All right. Are you going to want a few minutes to talk with your client after this, or did you have enough time beforehand?
I wanted to follow up with it because he had a question when we started.
All right. Okay. All right. We're going to go ahead and finish this, and then I'll give y'all some time to talk in the back. I want to talk with you before you go back there, though, Mr. Dark, about the appropriate way to handle attorney conflicts. All right. So this hearing is out of close. Thank you.